You must understand the historical context in which this happened. This has not happened in an isolated fashion. The Parliament of India, the Constituent Assembly in India, framed a constitution which included a provision for a Constituent Assembly.
Can we interpret it to include the Legislative Assembly?
But Manas, how can you interpret a term in a constitution which says Constituent Assembly as the Legislative Assembly? I don't understand, Manas. Under what concept of interpretation of the constitution will you do that?
Mr. Sibal, just as a, because we are not looking at it from that perspective yesterday, where was the first reference to the Constituent Assembly? Of course, the Constituent Assembly of the state finds a reference in the Constitution itself in Article 372,
Yes.
370 bracket 2. Where is the first reference to the Constituent Assembly in the documents which you read out to us yesterday prior to the Indian Constitution?
So there are two parts to it. First is whether the Parliament could have done it. That's a separate argument. But when we interpret the term Constituent Assembly for the purpose of the proviso to clause 3, can we, by implication, because at the time when the Constitution was enacted, at that time there was no Legislative Assembly for the state of Jammu and Kashmir. Is that factually correct? Answer is yes.
Yes, of course.
So then, when we interpret the term over here, can we interpret it to include the Legislative Assembly?
But Manas, how can you interpret a term in a constitution which says Constituent Assembly as the Legislative Assembly? I don't understand, Manas. Under what concept of interpretation of the constitution will you do that? There is no implied power. There is no express power. I mean, you can change any definition of any constitution.
That may not be. That will be it. Look, the term Constituent Assembly, when it is used in the proviso to clause 3, at that time there was no Legislative Assembly.
For the purpose of framing the constitution that the Constituent Assembly is formed. That's not, Malad, there's nothing to do with the legislature, which is why, Malad, Keshavnand Bharti.
See, the explanation which has been enacted was afterwards, is sometimes in 1952. Explanation enacted and has been made part of part 1, clause 1, was probably in 1952, if I'm not mistaken.
It was there, Malad.
No, initially there.
It was amended later on. That's not, it was there, but
it was there, it was amended
yes,
later.
Yes.
Because at that time, then the Legislative Assembly was brought in. Council of Ministers was brought in. Because at that time, there was no council.
Governor Malad was had to be.
There was no council of ministers at that time.
That was the Maharaja Malad. But that issue doesn't arise here. We're talking about Malad, a Constituent Assembly, the power of the Constituent Assembly. And you have now, there are now the Keshavan Bharti Malads, fortunately and unfortunately, sets the law.
Mr. Sibal, just as a, because we are not looking at it from that perspective yesterday, where was the first reference to the Constituent Assembly? Of course, the Constituent Assembly of the state finds a reference in the Constitution itself in Article 372,
Yes.
370 bracket 2. Where is the first reference to the Constituent Assembly in the documents which you read out to us yesterday prior to the Indian Constitution? I find that in the proclamation of the Maharaja.
Malad, they are in the Constitution debates, Malad.
I find that there's also a reference in the proclamation of the Maharaja which we read out yesterday. The reason I'm asking is this.
It's probably there, yes.
Sorry?
Karan Singh's proclamation, I think.
Yes.
Huh? I've already mentioned that in the Constituent Assembly debates. Iyengar, Malad, your lordship will remember.
Yes.
I quoted Malad's sentence.
Yes, volume 8.
All there, Malad. Yes.
Page 117. Yeah, Mr. Gopal Swami Iyengar's.
Yes.
No, because when the Maharaja made the proclamation, when the Maharaja issued his proclamation on 5th of March 1948.
It was contemplated by the Constitution and the Constitution makers that there would be a Constituent Assembly which would come into place, which happened in 1951.
Right.
That's what happened.
What happened first was that when the Maharaja made his proclamation in 1948, he spoke of a National Assembly.
Yes, absolutely.
Right? He says, my Council of Ministers shall take appropriate steps as soon as restoration of normal conditions have been completed to convene a National Assembly based upon adult suffrage. Then 5, the Constitution to be framed by the National Assembly
Yes.
shall provide adequate safeguards for the minorities and contain appropriate provisions guaranteeing for the freedom of conscience.
right.
Now, what appears to have happened was that before elections were held, by adult suffrage, they composed the Constituent Assembly. That's how the Constituent Assembly
Yes.
came into existence. Now, your whole argument is, of course, that what is to be done by a Constituent Assembly cannot really be done by a legislative assembly, and therefore less so by the central government assuming the character of a legislative assembly under 356. That's the what happens then if there is no Constituent Assembly?
I'm sorry, Mal?
What happens if there is no Constituent Assembly? Do you have to create a Constituent Assembly afresh?
Well, that is precisely between 1948 consultations. Well, that your lordship will
No,
remember.
now what would happen? Suppose they keep aside the procedure which they followed. We're keeping that aside for a moment.
Correct.
373 postulates the Constituent Assembly has to give its
Right,
recommendation
right.
on any proposal for abrogation.
Right.
Suppose the president were to move a proposal for abrogation. According to you, how would that be effectuated now, say in post-1957 India?
Let me answer that in two parts. Number one, what my lord is putting to me is in 1948, they contemplated a National Assembly.
Right.
But your lordships must remember that those were years between 1948 and 1950, especially after 1947, after the Instrument Accession was signed, Mullah. After the Instrument of Accession was signed, those were transitional periods. And when the Constitution came to be framed, there was a dialogue between the state of Jammu and Kashmir, that then stood through the Maharaja, and the government of India. And both of them decided that we will put this into the Constitution, that is 370, use the term Constituent Assembly, and you will then set up a Constituent Assembly to frame the Constitution and decide what you want to do. You must understand the historical context in which this happened. This has not happened in an isolated fashion. The Parliament of India, the Constituent Assembly in India, framed a constitution which included a provision for a Constituent Assembly of Jammu and Kashmir. Surely that was not an isolated act. This happened in consultation and in agreement with the then Maharaja.
And the J&K Constitution contemplates that this legislative assembly will have no role in regards to the amendment of the provisions of the Constitution relating to Article 370.
Otherwise, they would not put that phrase.
But then how would that, what sort of the
next question is, supposing there was no Constituent Assembly. That's the next
how
question.
do we, then what
Well,
constitutional
if there was no
mechanism would be
Constituent
envisaged then?
If there were no Constituent Assembly and your lordships were sitting in 5, I would have answered that question. But luckily, we have a Constituent Assembly.